Career is a very important thing in one's life. However, all people have lean phases in their career, like when an employee is terminated from a job. So now, I will discuss legal termination. We should remember that there should always be justification for terminating an employee. To protect your company from lawsuits, a damaged reputation, you need to ensure you have policies in place surrounding termination procedures. These policies should address ways to legally and ethically fire an employee. Now, let's start by exploring legal ways to terminate employees and also the law surrounding termination. Here in the Philippines, there are two types of employment termination. These are termination by employer and voluntary resignation or termination by employee. In termination by employer, you can only terminate an employee in the Philippines if you have a just cause or an authorized reason. A just cause can be an employee's unethical behavior or negligence, meaning to say, just causes are primarily causes where the employee is at fault, faults and misbehaviors of the employee. Here, the effectivity date of dismissal is determined by the employer. Employer is not legally liable to give separation pay to the dismissed employee. On the other hand, authorized causes are business-related causes when there are business contingency that force termination. So this is business and economic reasons. So here, employer is legally required to give separation pay to the employee, except in the case of company closure or cessation of operations due to business losses. And also, no hearing needed, and employer has to give the employee and dole written notices 30 days ahead of the projected separation. Remember that to end an employment contract, you need to document the employee's behavior and bring out the specific instances that led to termination. Also, if you as an employee suffers from a health condition that lasts more than 6 months, or the law prohibits you from working with such disease or working is harmful to yourself and also to your coworkers, then the employer is entitled to terminate your contract. So now let's discuss about what is under the just causes. So first is serious misconduct. So we know that serious misconduct is an improper or wrong conduct. No? So it is a transgression of some established and defined rule of action. So it is considered as a forbidden act and willful in character, and that it implies wrongful intent and not mere error in judgment. So here in misconduct, for it to be serious, it must be grave and aggravated in character, and it should not be mere trivial or unimportant. So it also needs to be connected with the work of the employee to constitute just cause for his separation. So the example for serious misconduct are drug use, habitual drunkenness, acts of immorality, and sexual harassment. So, sexual harassment is a very serious misconduct. So, in willful disobedience, when we say willful disobedience, it is about the refusal to obey orders, regulation, and instructions, which are reasonable and lawful. So next is neglect of duties, gross and habitual neglect of duty. So here, it is the failure to observe work standards and fulfill work assignments. No? So, in this neglect of duties, an employer has the right to impose productivity standards. Thus, failure to observe this may constitute just cause for dismissal. For example, job abandonment. No? So, job abandonment without valid reason, and second, with clear intention to sever employer and employee relationship. So, next is a fraud or deliberate breach of trust. So, we know that fraud is any act or omission or concealment which involves a breach of legal duty, trust, or confidence justly reposed. So here in fraud, the fraud must be committed against the employer or representative, and it should have a connection with the employee's work. So it also need to be willingfulness or wrongful intent. So for example, a supervisor was dismissed after asking another employee to punch in his time card for him. So this is falsification of time card. So the Supreme Court agreed with his dismissal because he had been previously disciplined several times for infractions. In fact, he had been suspended before for asking another employee to punch in his time card. He'd also been warned that he would be dismissed if he did it again. So he tried to claim that he had never been disciplined in his time with the company. However, the company presented several previous disciplinary actions. So that repetition of an offense clearly indicated willfulness. So that is an example of fraud, falsification of time card. Now let's discuss about loss of confidence. So when we say loss of confidence, it is when an employee concerned holds a position of trust and confidence. So it is the breach of this trust that results in the employer's loss of confidence in the employee. So as I mentioned earlier, this loss of confidence covers only two types of employees that have an employer's trust and confidence. First, an employee with managerial functions, or an employee who manages and safeguards his employer's money or property, like I mentioned earlier. So, personal occupying positions of responsibility like cashiers, managers, supervisors, salesmen, bank tellers, and the like. So, for example, okay, an employee who holds a position of trust and confidence like a waitress in a hotel that is responsible for bringing discount cards to the cashier and presenting the discounted bill to the guest. So instead of presenting the discounted bill to the guest, she gave them the original bill and pocketed the discount. So being therefore involved in the handling of company funds, the employee is undeniably considered an employee occupying a position of trust and confidence, and as such, and was expected to act with utmost honesty and fidelity. So now let's move on to commission of crime or offense. So crime against the employer or the employer's family member. It could be a spouse, descendants, siblings, legitimate, natural, or adopted, or siblings of his relatives. And here, an employee may be acquitted in a criminal case and yet his dismissal by the employer may remain. The only requirement mentioned in commission of a crime and not conviction. Okay? I mean, the only requirement mentioned is commission of a crime, not conviction. To convict a criminal requires proof beyond reasonable doubt, and to dismiss an employee, it requires only substantial evidence. So now let's discuss about the authorized causes. In Article 283, it states that you can also terminate an employee for authorized causes including business reasons, such as first, installation of labor-saving devices. So, labor-saving devices or automation, it refers to the reduction of the number of workers due to new machinery. Of course, manufacturer has the right to use new labor-saving devices with an aim to effect more economy and, of course, efficiency in production. So, next is redundancy. When it comes to redundancy, it is where the services of an employee are in excess of what is actually required by the industry. Maybe it could be maybe due to overhiring of workers, there is a decreased business volume, or dropping of a product line or service activity, streamlining, mergers, and reorganization. So here in redundancy, management must show adequate proof that the abolished positions were really unnecessary. So now, reduction of costs to prevent losses or retrenchment. It is a termination of employees due to substantial and eminent loss. And this loss must be, of course, proven by the convincing evidence. So here, the termination is also done when it is seen as a necessary step in effectively preventing further losses. So, of course, there are conditions like um, this termination is intended to prevent losses and such losses are proven. Second, written notices are served on the workers and the dole at least 1 month before the effective date of retrenchment. Third, separation pay is paid to the affected workers. And fourth, there must be fair and reasonable criteria in determining the employees to be dismissed. Here, for example, temporary employees first, efficiency rating, and seniority. So, in selecting employees, there is a rule that they follow, like, they can follow, like the last in, first out rule. Though not statutory, has its merits. So, selection is part of management's prerogatives unless this is stipulated in a CBA for organized companies. So, later on, I will discuss what is last in, first out rule. So, second is the closing or cessation of operation. So, here, the firm is required to cease operations due to, for example, government mandate. Government mandate like acquisition of land for agrarian reform, or the firm is suffering serious business decline and loss, or if the firm owner wants to discontinue business for personal reasons but in good faith is allowed to close. So, cessation not due to business loss should meet the following conditions. There should be a written notice to employee and dole at least 1 month before intended date of termination, and cessation from business operations must be bona fide in character. And lastly, of course, payment to the employees or of termination. Pay amounting to at least 1/2 month pay for each year of service or 1 month pay whichever is higher. So again, like I've mentioned earlier, disease could be a ground for termination. I've discussed this earlier. And in addition, medical certificate issued by a competent public health authority is still needed for termination to take place, even though disease does not warrant the employee to continue working according to law or as considered detrimental to his own health or the health of his coworkers. So here, there is no hearing needed, and of course, the employer has to give the employee and dole written notices 30 days ahead of the projected separation.
What is a sanction if the employer failed to observe procedural due process in cases of legal and authorized termination? In cases of termination for just causes, the employee is entitled to payment for indemnity or nominal damages in a sum of not more than 30,000 pesos. In case of termination for authorized causes, 50,000 pesos. So, ano nga ba yung procedural due process? Procedural due process ay ang proseso na dapat sundin ng isang employer para ma-dismiss ang isang empleyado mula sa kanyang trabaho according ito sa Article 292B ng Labor Code of the Philippines. Kapag na-dismiss ang isang empleyado nang hindi nasusunod ang procedural due process, ito ay labag sa karapatan ng manggagawa at masasabing siya ay illegally dismissed mula sa kanyang trabaho na walang due process. Right to security. The right to security of tenure means that a regular employee shall remain employed unless his or her services are terminated for just or authorized cause and after observance of procedural due process. So, security of tenure, according sa Article 294 Labor Code of the Philippines, ay ang isang empleyado ay hindi pwedeng ma-dismiss sa trabaho maliban na lang kung may just cause or authorized cause ang kanyang employer. Kung nilabag ng employer ang security of tenure ng isang manggagawa, hindi pwede magdemanda yung empleyado ng illegal dismissal laban sa kanyang employer sa labor arbiter. Components of procedural due process. Due process in the context of employment termination is the right of an employee to be notified of the reason for his or her dismissal and, in case of just causes, to be provided the opportunity to defend himself or herself. So, according sa Labor of Code of the Philippines, lahat daw ng uri ng empleyado at manggagawa sa private sector mula rank and file, supervisor hanggang managers at kahit ano pang classification niya, probationary, regular, seasonal, project-based, or casual, ay may karapatang mabigyan ng procedural due process. So, magsisimula yung procedural ng dismissal of an employee based on just cause kapag nabigyan ng employer yung manggagawa ng first written notice or notice to explain. Ay, nakasulat nun sa due process is different for both authorized and just causes. Ayan. Nakasulat na dyan sa letter A notice of intent to dismiss specifying the ground for termination and giving said employee reasonable opportunity within which to explain his or her side. So, dapat dun sa notice na yun, naka-indicate lahat ng specific ground for dismissal ng manggagawa ayon sa Article 297 ng Labor of Code of the Philippines or Company Policy. So, yung notice, magbibigay yun ng opportunity sa employee to answer the complaint. Yung employee, mabibigyan siya ng pagkakataon na mapag-aralan ang yung paratang sa kanya. Pwede siyang kumonsulta sa union officer or sa abogado para makapaghanap ng relevant information or at evidence yung employee para maging basihan ng kanyang depensa. Pwede rin siyang maghain ng request para siya ay bigyan ng employer ng mas mahabang panahon para sagutin yung notice to explain yung binigay sa kanya. Kung hindi rin naman nilagay ng employer ang evidence dun sa notice to explain, pwede itong hingi ng employee dun sa employer. Kung malabo naman yung kwento ng pangyayari sa notice to explain, pwedeng mag-request yung employee na linawin ng employer yung kwento. Pwede din namang pagkabigay ng employer sa manggagawa ng notice to explain ay dapat bigyan ng employer ang manggagawa ng pagkakataong sagutin ang mga paratang sa kanya. So, next nun is yung hearing or conference where the employee is given opportunity to respond to the charge, present evidence, or rebut the evidence presented against him or her. So, yan. Next naman nun is a notice of dismissal indicating that upon due consideration of all the circumstances, grounds have been established to justify termination. So, ayun yung last process. B, in a termination for an authorized cause, dapat nabigay na yun ng employer dun sa employee at least 30 days before the date of termination. And also, a copy of the notice shall also be furnished the regional office of the Department of Labor and Employment where the employer is located. What are the rights afforded to an unjustly dismissed employee? An employee who is dismissed without just cause is entitled to any or all of the following: reinstatement without loss of seniority rights, security of tenure, provision ng Labor of Code Article 294, ang illegally dismissed employee ay kailangan ma-reinstate sa kanyang position, na ang tinutukoy ng batas dyan ay yung mga empleyado na nag-file ng dismissal case against the company at nanalo with finality sa mga proceedings or sa labor or sa Court of Appeals man kung umabot sa Supreme Court. At kailangan nang i-execute yung decision na ibalik sa trabaho yung empleyado kung hiniling niya sa kanyang complaint na ma-reinstate siya sa trabaho. Next is, in lieu of reinstatement, an employee may be given separation of 1 month pay for every year of service. Next is pullback wages, inclusive of allowance and other benefits of their monetary equivalent from the time compensation was withheld up to the time of reinstatement. Ito yung lahat ng na-earn ng employee pero hindi na-kolekta since dun sa unjust dismissal niya. Makukuha niya yon. It includes all the amounts she could have earned starting from the date of the dismissal up to the time of reinstatement. Next is damages if the dismissal was done in bad faith. So, ayan. Next is statement. Reinstatement means restoration of the employee to the position from which he or she has been unjustly removed. Reinstatement without loss of seniority rights means that the employee, upon reinstatement, should be treated in matter involving seniority and continuity of employment as though he or she has not been dismissed from work. So, ayan, nabanggit ko siya kanina na pwedeng mabalik yung employee sa kanyang position dun sa trabaho once na nanalo siya dun sa complaint or sa case na na-file against sa kanya.
Good day, I'm Aaron Joshua Tolentino and my assigned topic for today is letter B, when an employee quits. My topic assigned is resignation and types of employment termination. So, resignation is the voluntary act of an employee who is in a situation where one believes that personal reasons cannot be sacrificed in favor of the exigency of the service. So, exigency means it is the urgently needed work to provide product and services which in failing to do so may result into serious delay or damage to the company. So, sa pagiging professional, sa pagiging professional mo balang araw, resignation yung isa sa pinakamahirap na kaharapin, no? Siguro para sa iba, isa to sa mga pinakamahirap na sitwasyon sa professional life or sa professional career mo, di ba? And ayun, dako naman tayo sa types of employment termination. Resignation is under siya dito sa types of employment termination kasi may iba't ibang klase nga na pag-terminate, at isa doon is yung resignation. So, number 1, termination by employer. Employer can only terminate an employee in the Philippines if they have a just cause or an authorized reason. So, a just cause can be a employee's unethical behavior or negligence. So, nabanggit dito yung just cause or unauthorized reason. So, yung isa sa mga example ng just cause is yung pagkakaroon ni employee ng unethical behavior at kapabayaan sa trabaho, no? So, upon sa may experience sa pagtatrabaho sa food industry, may isa na akong katrabaho na nahuling nagnakaw. At nung nahuli kinabukasan, yung schedule niya nung linggo na yon kinancel na at hindi na siya pinabalik nung head namin, no, nung boss namin. ng employer namin. Hindi na siya pinabalik na para pumasok pa kasi iyon isa yun sa grounds for termination, no? So prohibited yung pagnanakaw. And isa yun, mag-under yun sa unethical behavior. Sa negligence naman, um, pwedeng isang example dito is yung pag-aawol yung absence without official leave, no? Syempre, binigyan ka ng schedule ni manager na kailangan mong pasukan para makatulong sa pag-growth ng company, tapos hindi mo papasukan, a-absent ka lang ng walang dahilan, hindi ka nagpaalam ng maayos, no? So malaking kawalan din 'yon sa company, lalo na kung fixed salarization yung rules doon sa company na napasukan mo. Naka-fix yung yung sahod mo, kaya gusto mo lang umabsent na umabsent. Ganun. So number 2, voluntary resignation by employee. It is when the employee decides to resign. No? So, according to Article 285 of Labor Code of the Philippines, employees can quit their jobs either with or without just cause. So, if the employee failed to submit a formal resignation letter, the employer can charge them for any concurrent damages. So, nabanggit din dito yung with or without just cause. So, kanina nabanggit yung sa pagkakaroon ng dahilan kung bakit ka pwedeng matanggal o mawala sa trabaho. Dito naman sa resignation, yung employee is voluntarily siyang magre-resign o aalis sa trabaho. So, maraming dahilan din ito. Isa na rito yung personal matters, no? So, kung nakikita mong ikaw as employee, kung nakikita mong hindi na nag-grow yung professional career mo sa company na yon, why not na mag-resign, di ba? Bakit naman hindi ka magre-resign at maghahanap ka ng bagong opportunity sa ibang company? So, ganun. If ever naman na hindi nakapag-submit ng formal resignation si employer pwede siyang worst case pwede siyang kasuhan, no? sa pag hindi sipot ng o pagpasa ng resignation letter, ng formal resignation letter. Ibig sabihin, 'di ba, formal kang hinire tapos aalis ka na lang ng walang maayos na proseso, 'di ba? Yung mag-aawol ka na lang, a-absent ka na lang ng ilang linggo hanggang sa tawagan ka na ng HR manager nyo na yayain ka na mag-resign, no? So, pangit yun sa pagtatrabaho kasi 'di ba tinanggap ka ng maayos tinanggap ka ng may formal na proseso, tas aalis ka ng nang hindi nagpapaalam ng maayos o nang walang formal na proseso. So, yun, yung resignation letter, may ipapasa mo yon within 30 days bago ka mag officially resign, no? So bakit nga po ba 30 days? So dito naman sa next slide, why it is needed to have a 30-day notice before the official resignation. So it is for the benefit of the employer to have enough time to seek new applicant that has the credentials for the job that will suffice the vacancy in the company, and to have also a proper turnover or of the task which the resigning employee handling. So, ayun, halimbawa na lang, nasa isang mataas na posisyon ka na sa company nyo, tapos gusto mo na mag-resign. So, yung 30-day notice na yon kasama doon sa proseso nung resignation mo. Siyempre, kailangan mo munang tapusin yung mga naiwan na trabaho. Yung mga naiwan mong trabaho, kailangan mo munang tapusin nang sa gayon maayos yung pagre-resign mo. At mabigyan ng oras si employer na maghanap ng aplikante na angkop yung credentials doon sa mabivacant na trabaho sa company, no? So, ayun. Number 3, termination of a probationary employee. If this period becomes evidently that the employee fails to meet the company's standard, the employer are eligible to terminate their contract. So, bago ka maging regular sa isang trabaho, dadaan ka muna rito sa probationary period, which is a span of 6 months. 6 months probationary period. So dito lahat ituturo sa iyo yung mga companies set of standard and procedural methods, no? So pag natapos yung probationary period na yon nang hindi ka pa natututo o nag-i-improve, candidate ka for termination, no? At si employer mo ay may kapangyarihan na i-terminate yung kontrata mo at wag ka nang ipagpatuloy sa pagtatrabaho doon sa company. So ayun, next slide. Yun nga, gaya ng nasabi ko kanina, an employee may terminate without just cause the employee-employer relationship by serving a written notice on the employer at least 1 month in advance. No? So, usually naman yung resignation letter, hard copy yan eh. But, nowadays, kailangan, may nalaman ako na kailangan magpasa ka ng isang hard copy at software or online copy. Kasi ngayon, 'di ba, kadalasan halos lahat work from home, kailangan ng social distancing, ganun. At ayun, sabi rin base din doon sa understanding ko sa research ko, walang specific na format yung pagsusulat ng ng resignation letter. Basta may naka-indicate lang na I hereby tender my formal resignation effective 30 days after or on. Tapos i-indicate mo dun yung date kung kailan mo gustong matapos na yung kontrata mo. Basta 30 days yung duration. So, ayun, nabanggit ko na kanina bakit kailangan 30 days. Yung process or yung kailangan na hintayin bago ma-approve yung resignation mo. So, lastly, syempre kailangan mo ng pirma doon sa dulo, no? Na ikaw ay sumasang-ayon na rin na mag-resign doon sa company na pinapasukan mo. And lastly, syempre kailangan ng approval ni employer or ni HR manager. O kung ano man yung nag-hand ng 201 file or ng mga employees. So ngayon, dako naman tayo sa what is separation pay. So separation pay is the amount of compensation you may get if your termination is due to authorized causes. So kanina nga nabanggit ko nung sa first part, 'di ba? Na na si employer ay pwedeng mag-terminate with just cause or unauthorized reason or authorized causes. So, ano nga ba yung examples ng authorized causes na sinasabi, no? So, meron tayong mga examples dito. Isa na rito yung redundancy, retrenchment, installation of labor-saving devices, at yung employee is suffering from a disease and continued employment is prohibited by law, prejudicial to his health as well as the health of his co-employees. So, una, yung redundancy, ito yung simpleng pag-laid off o pagbabawas ng tao sa isang company na para maiwasan yung unexpected expenses or labor cost na tinatawag, no? So, same thing din sa retrenchment. Pagbabawas lang din ng gastusin sa company ng unusual or unexpected expenses. And yung installation of labor saving devices, no? So diyan papasok yung mga makina at robots, no? So isa sa mga examples dito is yung katulad nga nung sa amin sa food industry na pinapasukan ko. Kung meron man dito sa inyo na napapadpad sa McDonald's, may makikita na kayo doon na ng parang TV, no? TV na touchscreen. So tawag doon is self-ordering kiosk na kung saan si customer na mismo yung pwedeng mamili ng kanyang order na o-orderin. No, hindi niya kailangan makipag-usap sa tao para i-punch yung order niya. Siya na mismo yung pipindot, no? So, ayun, isa yun sa mga examples ng installation of labor saving devices. So, ano yung maging epekto nun sa company at sa mga employee? Syempre, mababawasan na yung tao na kikilos kasi meron nang machine na gumagana para ma-suffice yung service na kailangan. At ayun, sa ano na rin, pagtitipid na rin sa labor cost, kung mataas man o hindi. So, yun yung lastly, yung si employee ay nagkaroon ng malubhang sakit na hindi kayang um, magamot within 6 months, no? So, they are also entitled to have the benefit of separation pay. So, according sa Article 284 ng Labor Code of the Philippines, this is as ground for termination. So, an employer may terminate the service of an employee who has been found to be suffering from any disease and whose continued employment is prohibited by law or prejudicial to his health as well as to the health of his co-employees. No, so, ito yung isa sa mga pinakamasakit na pangyayari o pwedeng mangyari sa isang employee sa isang kumpanya, no. Yung gugupuin siya ng sakit tapos hindi na siya papayagang makapagtrabaho dahil dun sa sakit niya na hindi kayang gamutin nga ng within 6 months. So, entitled sila para makakuha ng separation pay with the discretion, of course, of the company. Depende pa rin yun sa rules and policies ng company na pinasukan mo kung nagbibigay ba sila ng separation pay. So, the employers are not required to pay separation compensation if their employee leaves voluntarily. The benefit only applies if the employee loses their job due to reasons that are not their fault. No? So, gaya nga ng nabanggit ko kanina, yung authorized causes ay isa sa mga dahilan o grounds para makatanggap si employee ng separation pay. So, paano nga ba nako-compute yung separation pay? So, may base dun sa na-search ko, meron dalawang paraan para computein yung separation pay. Again, depende pa rin to doon sa company na napasukan mo. If depende pa rin doon sa policies and rules ng company na pasukan mo, yung kung magkano yung makukuha mo doon sa separation pay na matatanggap mo. So, yung isang formula is 1 month salary times kung ilang taon kang nagserbisyo doon sa sa company na yon. So, kung fixed salary ka, halimbawa 10,000 per month yung sweldo mo, tapos 5 years ka nagtrabaho, may entitle ka ng for 50,000 ng separation pay. So, sabi rin nung nanay ko na minsan na nagtrabaho sa mga company na katulad ng Pure Gold, nabanggit niya na yung ibang company ay nagbibigay ng 100% pay, no, doon sa mga employees na na pumasok na ng 5 years or 10 years doon sa company na yon. They are entitled of 100% separation pay. Pero again, depende pa rin yun sa company na napasukan mo. Sa ibang companies naman or sa ibang formula, yung isang cut-off lang ng 1 month salary mo, yung kalahati lang nun, yung ipoprovide at kung ilang taon ka ulit nag-serve doon sa company na yon. So, in addition, last na po, yung pinagkaiba ng final pay versus separation pay. So, final pay, ito rin yung parang back pay na matatanggap, no? So, again, this is from the discretion of the company. If, kung nagbibigay sila ng back pay sa mga employee nila na nag-voluntarily resigned, no? So, ano ba yung final salary? Ito yung prorated 13-month pay na pwede mo matanggap. Halimbawa, nag-resign ka ng mga bandang October. So, ibig sabihin, lagpas 6 months ka na nagtrabaho doon sa company na yon. Pwede mo pa rin matanggap yung prorated 13-month pay mo. Yun nga lang, yun tawag nga doon yung prorated 13-month pay. Yun nga lang, from January to October, yun lang yung makukuha mong 13-month pay. So, ito rin, kung paano rin computin to, equivalent lang din naman to ng isang buwan mong sahod, no? So, imagine kung magre-resign ka na ng October, parang 2 buwan na sahod na yung makukuha mo pag nag-resign ka. So, maraming salamat po sa pakikinig. Sana may naintindihan po tayo.
Good evening, I am Mary Lori A. Santos and my topic is about furlough. Furlough is mandatory and strictly enforced, which means hindi ka maaaring makapagtrabaho sa iyong employer. Furlough offers benefits to both employers and employee over layoffs. For the employer, a furlough is a way to save on cost during a time of economic hardship. So, kapag wala ring enough na cash for payroll, maaaring ipatupad ito ng isang kumpanya. Ang furlough, isa siyang mandatory temporary leave of absence ng mga empleyado at inaasahan na magre-return din sila sa trabaho or maaaring mag-restored sila kapag nag-reduce na yung work schedule. For example, due to the COVID-19 virus, maraming kumpanya ang nagpatupad ng furlough sapagkat limitadong empleyado lamang ang kailangan. So, makikita ninyo sa larawan, isang ospital, yung bumaba ang revenue, so kinakailangan nilang mag-cut hours into 300 workers lamang. So, my next topic is all about what to do when an employee quit. Bilang manager or HR, syempre gusto mong malaman kung bakit gustong umalis ng empleyado para na rin malinaw kung ano talaga ang tunay na dahilan sapagkat maaaring ang dahilan nito ay ang nararanasan niya sa kumpanya at maaaring ito ang magiging way upang maayos at mabago ng kumpanya ang naging problema. Kung ano man ang naging rason ng isang empleyado sa kanyang pagre-resign, ito ang recommended procedures for employers to follow in order to handle an employee resignation with dignity, professionalism, and grace. Number 1, obtain a resignation letter. Sabi nga ni Aaron, base sa Article 285 ng Labor Code, kinakailangan ng empleyado makapagpasa ng isang resignation letter upang idokumento niya na voluntaryo ang kanyang pag-alis at kinakailangan na nakalagay doon ang petsa ng kanyang pag-alis upang mapaghandaan ito ng kanyang manager at maipasa ang mga naiwan niyang tungkulin. Number 2, transfer responsibilities or knowledge. Make sure na lahat ng duties and shift na covered ng empleyado ay maito-transfer mo sa ibang empleyado. Kailangan mong mag-conduct ng hiring para hindi masyadong mabigat sa mga naiwan na empleyado ang kanilang tungkulin. Maaari mong ipalista sa empleyado na aalis ang lahat ng mga bagay na ginagawa niya upang matulungan ka nitong malaman ang eksaktong pag-distribute ng gawain. Isang paraan din ito upang mas maging organisado ang paraan ng pagpuna sa responsibilidad o tungkulin ng umalis habang naghahanap ka ng papalit na empleyado. Number 3, provide required notice. Sabi nga ni Aaron, based on the Article 285 ng Labor Code, kailangan mag-comply ng empleyado sa 30 days notice and service. Number 4, comply with the legal basis. Ito yung pinakamahalaga na dapat gawin at sundin ng employer sapagkat kapag hindi ito nasunod, maaaring umabot sa pagrereklamo ang empleyado. Nakabase dapat ito sa Article 285 ng Labor Code at natalakay naman na ni Aaron ang mga nakapaloob dito. Number 5, obtain company property. Required na isoli ang mga company issue property sa huling araw gaya ng uniforms, ID, cellphone, laptop, and keys. Number 6, confirm mailing address. Kailangan ma-verify na updated lahat at tama ang mailing address ng empleyado para sa pagpapadala ng final pay kung ito man ay applicable. Number 7, notify key stop and contacts. Kailangan ihanda ang listahan ng mga stop, clients at contacts upang maging aware sila sa nalalapit na pag-alis ng empleyado. Number 8, conduct an exit interview. Kailangan mag-conduct ng exit interview dahil ito ang isang paraan upang malaman mo ang tunay na rason o dahilan kung bakit aalis ang empleyado. Upang malaman mo ang katotohanan, dapat ay neutral lamang ang pagtatanong sa ganitong pagkakandak ng interview instead na gawin mong direct supervisor.
So good day everyone, my name is Erica Jain Villarosa and I'm going to discuss to you about layoff. So layoff considered separations from employment due to lack of work available. So layoff can be either temporary or permanent. So in times of financial crisis, many companies, especially during pandemic, find that they need to lay off workers for different reasons. So the most common reasons why employers are laid off includes shortage of their raw materials, business-related issue, cost-cutting, staff reduction, and relocation. So relocation, it is a moving the company operations from one area to another, and can also bring about the need to let go of some workers. However, company's owner may have reasons to believe or hope it will be able to recall the workers back to work from layoff if they will choose other options. So, employees in a late career layoff may be given early retirement, meaning they will stop working and cease collecting a paycheck but will remain eligible for retirement benefits. So, best example of a lot of workers or owners na nilay off nila yung mga workers nila is during the pandemic. So, small and big businesses are tend to close during the pandemic because we experienced a lot of quarantines, lockdowns, and dahil doon, nalimitahan yung mga operation ng mga companies and businesses. In that, the owner of the businesses decides to lay off some of their workers. So to encourage the laid-off employees to remain available for recall, some employers may offer continued benefit coverage for a specified period of time. If the benefit plans allows alternative layoffs, so it's called alternative layoffs. So alternative layoffs includes pay cuts, work sharing, offering early retirement, unpaid time off, cutting back on the extras, and adopting virtual work setup. So, madalas na gumamit ng adopting virtual work setups is yung mga nagtatrabaho sa call center agent wherein dinala nila yung work setting nila sa bahay para mag-continue yung work nila at hindi sila mag-alternate or mag-lay off or mag-first leave ng company nila. So, ginawa nila is dinala nila yung mga equipment, mga tools, materials kagaya ng desktop, computer, dinala sila sa bahay, doon sila nag-set up para mag-continue yung working nila and hindi sila ma-force leave ng company nila. So, in the Philippines employment law about temporary layoff or forced leaves, so in our constitutions, Article 301 of the Labor Code, an employer in the Philippines has the management prerogative to place an employee on unpaid temporary layoff or forced leave in accordance with a requirement set by law and related jurisprudence. So, the owner, hindi niya kailangan or hindi biglaan yung pag-forced leave niya sa mga workers niya. So, kailangan is sumunod siya in the different set by law and related jurisprudence for them to be fair and um, fair and justice sa pag-force leave sa mga workers niya. So, example of related requirements set by the law is such an arrangement must therefore be made on a valid and justifiable grounds and legitimate business reasons and not for the purpose of defeating or circumventing the rights of the employee. So, hindi si owner, hindi niya kailangan ma-personal siya sa mga employee niya. So, kunyari, ako galit ako kay ganito, ifo-force leave ko siya without any valid reason. So, hindi pwede yon. So, based yon sa Article 301 of the Labor Code. So, during the pandemic, there's a lot, gaya nga nasabi ko, there's a lot of business, small or large companies na nag-close because of the different quarantines na na-experience natin. So, si DOLE issued Labor Advisory number 9 series of 2020 and recognized, among others, forced leave as an option in response to the pandemic. So, under the Labor Advisory number 9 series of 2020 as reiterated in DOLE Labor Advisory number 17 series of 2020, employers who are encountering financial difficulty due to COVID-19 may implement forced leave in their respective establishments. Among other alternative work schemes, even without the agreement consent of the affected employees. So due to immediacy that is required in the implementation of such work schemes. So, Labor Advisory number 9 series of 2020 only requires the employer to meet two specific formal requirements. So, bago mag-iba ng work scheme si owner, kailangan niya magpasa ng two specific formal requirements, which are first is to consult with the affected employees prior to implementation. So, kailangan niyang sabihan na ganito yung mangyayari, ganito yung mga possible na mangyayari. So, second is notify the DOLE by sending via email a completed establishment report at the soonest possible time. So, compulsory nature of forced leave and its impact on the affected employer who are intending to avail of this option must be prepared to prove that is made in good faith. So, kailangan si employer, bibigyan niya ng assurances yung mga workers na may magandang kalalabasan yung pagpo-forced leave sa kanila. So, mayroong valid reasons and justifiable reasons kung i-force leave niya yung mga employee niya at bigyan niya ng assurances na may mababalikan pa silang trabaho. So Article 301 of the Labor Code. So, in addition, an employer would also have to show that its employed fair and reasonable criteria in determining who among its employees will be affected. So, gaya nga nasabi ko, once na si owner ay forced leave ng mga workers niya, kailangan niya magbigay ng fair and reasonable criteria. So, isasabihin niya si worker kung bakit siya na forced leave. Ito yung mga criteria kung bakit ka na forced leave, ikaw yung napili. So, next is, and the employees who are similarly situated are treated in the same fashion. So, to sum up all of this discussion, so, si owner, if magpo-forced leave siya ng mga workers niya, first is kailangan niya maging fair and justifiable kung ano yung reasons bakit niya ipo-forced leave. So, kailangan maging fair, maging valid yung reasons niya, and kailangan yung purpose niya is hindi personal. Kailangan is transparent siya kung bakit niya ipo-forced leave yung workers niya.
Good evening, sir. Good evening, classmate. I'm Maripay Tamayo, and here's my report. What are your rights when you were laid off? Number 1. Your employer may be required to give you 30 days notice that you will be laid off. The Labor Code of the Philippines states that employee must be served the written notice or redundancy a month before the date of retrenchment task affect, you might find yourself staying around the office a little bit longer after. Number 2, pay the appropriate amount of separation pay to the employees. Reduction in force. A reduction in force occurs when a position is eliminated with no intention of replacing it and result in permanent cut in head count. An employer may decide to reduce its workforce by terminating employees or by means of attrition. In some circumstances, a layoff may turn into RIF when a permanent decision is made to not recall employees. Reduction in force are typically permanent because the roles of those let go are usually eliminated with the termination of employment. For example, suggest that the let go employee has the potential to get rehired once finance or the new strategy is in place. With RIF, through it's understood there is no option for rehire. Pay cuts is a reduction in an employee's salary. Pay cuts are more often made to reduce layoff while saving the company money during a difficult economic period. A pay cut may be temporary or permanent, and may be or may not come with a reduction in responsibility.